Yep.
Ma'am, can you tell me your name, please?
Karen C.B. Kilborn.
Okay. We'll go on the record in Kilborn versus Kilborn. This is file number 2511942. The record should reflect Ms. Kilborn's present today by video. Mr. Kilborn's present in the courtroom. This is set for a status conference today. So at this hearing, I usually try to determine whether there's been any agreements between the parties or whether there remain issues in dispute for mediation or for the court to decide. Ms. Kilborn, you're the plaintiff in this case. Can you tell me from your standpoint whether or not there are matters still in dispute between you and Mr. Kilborn?
No, there's not. We are only married for like 6 months. Well, not very long.
Okay. Mr. Kilborn, do you agree with that?
Yes, Your Honor.
Okay. Ms. Kilborn, did you want to finalize the divorce today then?
I would like to change my last name back to my maiden name if I could.
Yep, we can definitely do that. Other than that, are you prepared to go forward and finalize things today?
Yes, I am.
Okay. So I'm going to place you both under oath. I'm going to be asking each of you a series of questions. The questions I'm going to be asking you both are going to be those that I'm required to ask to establish the grounds for divorce under Michigan law. So can you both raise your right hands, please? Do you both solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, Your Honor.
Yes, Your Honor.
Thank you. You can lower your hands. Ms. Kilborn, as the plaintiff in this case, I'm going to start my questions with you. Ms. Kilborn, you filed a complaint for divorce in this case, and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, sir.
Had you been a resident of Crawford County for at least 10 days?
Yes, sir.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that your marriage could be preserved. Was that true when you signed that complaint?
Yes, sir.
Does that remain true today?
Yes, sir.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, sir.
Are you currently pregnant?
No, sir.
What are you asking to have your last name changed to?
Frisky. Freske.
Okay. Ms. Kilborn, will you be receiving any spousal support or alimony as a result of this divorce?
No, sir.
And you said that you've already divided up all the property between the two of you, including any assets or debts of the marriage.
Yes, sir.
Do you own any real estate or real property together?
No, sir.
All right. Mr. Kilborn, did you hear all the questions that I asked Ms. Kilborn?
Yes, Your Honor.
Did you hear all of her answers?
Yes, Your Honor.
Do you have any reason to believe that any of the answers she gave were untrue?
No, Your Honor.
Will you be receiving any alimony or spousal support as a part of this divorce?
No, Your Honor.
So, Ms. Kilborn, this is going to apply to you and Mr. Kilborn. Because neither of you are receiving or asking for alimony or spousal support, you both would be barred from ever bringing that back to the court and asking for that. Do you understand that, Ms. Kilborn?
Yes, sir.
Do you understand that, Mr. Kilborn?
Yes, Your Honor.
And Mr. Kilborn, do you agree that there are no issues regarding the division of any assets or debts that remain for the court to decide?
Yes, Your Honor.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce, and I've signed that judgment with today's date. That means that your divorce is final as of today. Ms. Stillborn, that also means that as of today, your name is legally changed, so you'll need to contact the clerk's office here to get a copy of this judgment. You'll need that to change your identification and other documents. Do you have any questions about that?
Can I pick that up Monday?
Yes, you can.
Great. Thank you, sir.
Yep, Mr. Kilborn, do you have any questions?
No, Your Honor.
Okay, thank you. That's all for today.
Thank you.
Thank you. Have a great day.
Yep, you're free to disconnect.
Great.
All set?
You're all set.
Thank you, sir.
Thank you. Mr. Isles, what case are you signing in under?
Gents versus Smith. We're scheduled for a settlement conference today.
I'm not seeing that on my docket. Sarah's gonna check the computer real quick here.
Thank you.
Scott, do you have a case number?
Hang on. We were supposed to have mediation by now, Your Honor, and our mediator had surgery, so we've been kicked back to October 23rd. I don't know, maybe something got noticed up that I missed.
Okay.
So, but we were originally scheduled for today.
There was a stipend order to amend the scheduling order done on 7/22.
Right.
The cutoff is now 11/9, and then today's date came off and it's reset for 1/8/26.
All right, that part of it I missed on the rescheduling order. All right, that'll work. You folks have a great day.
All right, thanks. Two.
Bye.
All right, it looks like we have counsel connected for our next file, which is Pickard versus Farmers Insurance and Tyler Rock. This is file number 251925. And if I could have all counsel, starting with plaintiff, put your appearances on in that file, please.
Good afternoon, Your Honor. Andrew Franklin on behalf of the plaintiff.
Good afternoon, Judge Elizabeth Speardon for defendant.
Okay. All right. I also have Mr. Muller listed as a defendant for Mr. Rock. Have either of you had any contacts with Mr. Muller?
Yes, Your Honor. We actually settled that portion of the claim, the third party portion. We sent a proposed order of dismissal up to the court earlier this week, so it sounds like it hasn't made the file yet, but it's en route.
Okay, all right, very good. So we're set for a scheduling conference in this case today then. So Mr. Franklin, on behalf of plaintiff, where are things kind of at? Obviously, we've had at least one party out of the case now. What would you like to see for scheduling going forward?
Well, my client's deposition is scheduled for October 20th. Since there's only the PIP portion that's remaining, I don't think there's a lot that's outstanding in terms of PIP benefits. So I'm hoping that once we get her deposition out of the way, I can get a demand over to Ms. Spearden's office and we can get it settled. I'm guessing, I don't want to speak for Ms. Spearden, but I'm guessing she's going to want to get some medical records and things like that. So I would think probably by the end of the year, beginning of next year, we'll, be in a position to wrap up discovery.
All right, Ms. Spearden?
Yeah, I think that's a reasonable time frame.
All right, I mean, Ms. Speardon, what do you think? Are you anticipating an early settlement in this case?
I don't know if I would say early, but like plaintiff said, we have the debt scheduled. We already have written discovery exchange. Some answers are already coming in. So I think we can get this one moving to get stuff going by the beginning of the year, maybe a facilitation around that time.
All right, I'm just trying to think of, sometimes when parties feel like the case will settle relatively early on, then I don't go through a full scheduling order and set a bunch of dates that we're never really gonna need. So I'm just wondering if maybe if we set a time for the cutoff of discovery, a deadline for that, and then maybe a mediation deadline, and then set this for another status conference and see where it's at that point. Mr. Franklin, what do you think about that?
I think that sounds reasonable, Your Honor.
Ms. Speardon?
I'm in agreement, Judge.
Okay, so why don't we say 90 days for discovery cutoff? That gets us through the first of the year. Maybe 120 days for mediation cutoff, and then I'll set this for a status conference at about 120 days. If the case doesn't settle either before or through mediation, then we can see where things are at, and then we can set some more dates going forward from there. Any objection to that time frame, Mr. Franklin?
No objection.
Ms. Speardon?
No objection, Judge.
Okay, Mr. Franklin, are there any other dates that I can address for your side here today?
No, Your Honor.
Ms. Speardon?
No, thank you.
Okay, so I will send out an order reflecting the dates that we've discussed today. You'll also receive notice of the date and time for that status conference hearing in about 120 days. If the case settles before that, just let my office know and we can take that date down so you both don't have to appear for that. But otherwise, we'll meet again then and we'll see where things are at. Thank you, and you're both free to disconnect.
Okay,
Thank you, Judge.
Ma'am,
Mhm.
can you tell me your name, please?
Sandra Ann Winans.
All right, this is Winans versus Amar, file number 2511927. Record should reflect Ms. Winans is present here in the courtroom today. I got this set today to enter a judgment of divorce, default judgment. Is that how you wanted to proceed?
Yes,
Raise
please.
your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
You can lower your hand. All right. Ms. Winans, I'm going to ask you a series of questions.
okay,
The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce.
Okay.
Okay.
Mhm.
So you filed a complaint for divorce in this case, and you signed that complaint. Is that true?
correct.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes,
Have you been a resident of Crawford County for at least 10 days?
yes,
In the judgment of divorce and in the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
yes,
Does that remain true today?
yes,
Are there any children under the age of 18 that were born to or adopted by you during marriage?
no,
Are you currently pregnant?
no,
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
yes,
Are there any issues regarding the division of any assets or debts of the marriage that remain for the court to decide?
no,
Do you own any real estate with Mr. Lamar?
no,
The court finds that the statutory grounds for divorce have been met by the testimony of Ms. Winans. I've reviewed the file. It does appear that Mr. Lamar was properly served with the summons and complaint in this matter,
Mhm.
that he failed to answer and or otherwise defend, so the court finds the default judgment is appropriate. And so I've entered that judgment, which means your divorce is final as of today. Do you have any questions at all?
no questions. Thank you, Your Honor.
Thank you, that's all for today.
Okay, I don't need to collect anything.
Yep, if you want to just have a seat, and we'll meet you right after.
Okay. Have a good afternoon.
Thank you. All right, council will go on the record in Menifee versus Save-A-Lot. This is file number 2511905. If I could just have council put your appearances on the record, please.
Good afternoon, Your Honor. Ali Saad on behalf of plaintiff Caroline Menifee.
And Peter Warden substituting in for Mr. Mueller today as counsel for defendants.
All right, we're on the record here today for purposes of a scheduling and status conference. So on behalf of plaintiff, Mr. Saad, can you tell me where things are at with this file today and what you'd like to see for scheduling going forward?
Yes, Your Honor. So we did recently get our discovery responses out to brother counsel. I think maybe they might want to depose my client. I don't suspect too much discovery is needed here. I do know they requested the records of my client's prior medical history, which I'm working on getting for them. But yeah, we've been trying to negotiate somewhere to reach a resolution in the meantime.
Okay, Mr. Warden?
That's consistent with my understanding of the case, Your Honor. No depositions have yet been taken. yes, we will want to take the deposition of the plaintiff. Council may probably elect to take depositions of one or two people from the store. Getting the medical records is always the toughest part. That's not our doing. It's not council's doing. It's just the medical providers are often slow to respond to the copy services. And we're in that process now.
Okay, well, I think maybe what we want to do in this case is set a discovery cutoff time and a mediation cutoff time. And then I'll set it for a status conference at that point. If the case hasn't settled, then we can talk about how to schedule further rather than setting up a bunch of dates out right now. It sounds like the parties are working towards that. So, Mr. Saad, if we set this for, you know, I don't know, 90, 120 days of discovery and then a mediation cutoff 30 days after the close of discovery. Do you have any objection to that?
120 days sounds good. The 30 days, I'm just concerned because I know facilitators have been booked out. So, and they're scheduling very, months out from now. So maybe that could be an issue, but if it's not an issue, I have no problem with that.
Okay, Mr. Warden.
A couple of things, Your Honor. First, Mr. Mueller, nice of him to do this. He sent me to you today to ask for 180 days, if at all possible, just to give us time to get the records and get the remaining discovery done and get our ducks in a row. And if not that, at least 150 days. I'm just worried that the shorter than that is going to be a little tight to get all the records. As for mediation, I didn't quite hear what the court said about the mediation deadline, but my standard position on this is I think mediation is best accomplished towards the end of discovery to give us a chance to get all that together. And then we all know what there is in there and what needs to be discussed. A lot of times earlier mediations fail because we don't have all the facts yet and everyone sort of digs into their position. It's a lot more effective when it's at the tail end of discovery.
Okay, Mr. Saad, any objection to 180 days for discovery?
No objection, Your Honor.
Okay, so that's a longer period of discovery than I really would like to set aside, but I understand what the council's saying. So we'll say 180 days for discovery, but I do want then the mediation to occur within that 180 days. I totally agree, Mr. Worden. Sometimes that works better at the end. So I'll leave that to council as to where the two of you think you're at a point. But that should give you 6 months should be enough time to do both of those things. And then I'll set this for a status conference at about 180 days. We'll check in. If the case did not settle through mediation, then we can discuss, motion cutoffs and looking at a trial schedule and so forth. And if it does settle, if council will let my office know, then I can take down that status conference and neither of you or Mr. Mueller would have to appear for that. I'll put those dates into an order. Council will get that order. And then you'll also get the notice of the date and time for that status conference at about 6 months. Mr. Saad, any other scheduling matters I can address for your side today?
None that I can think of at this point, Your Honor. Thank you.
All right. Mr. Worden, anything further from your side?
Nothing further, Your Honor. Only I'm just glad to see that they don't have you in plexiglass anymore.
Yeah, we finally decided that enough was enough with that. So yeah, I'm glad too. It felt weird being enclosed. So all right, thanks. You're both free to disconnect. Have a
Thank
good
you,
day.
sir.
Thank you, Your Honor.
Bye-bye.
All right, sir, are you Norman Kenyon?
Yes, I am, Your Honor.
Okay, just hold on one second.
No, that's Ms. Kenyon.
Ms. Kenyon, okay. All right, Ms. Kenyon, if that's you, I need you to unmute, please. There we go. Ma'am, are you Joyce Kenyon?
Yes, I am.
All right. Okay, we'll go on the record in Kenyon versus Kenyon. This is file number 2511895. The record should reflect both sides are present by Zoom video. I have this set as a date to enter a judgment of divorce in this case. Mr. Kenyon, is that how you wanted to go forward today?
Yes, please.
All right, and Ms. Kenyon, is that how you wanted to proceed as well?
Yeah.
Okay. All right, so I'm gonna have both of you raise your right hands, and I've got some questions I need to ask each of you to establish the grounds for divorce under Michigan law. Do both of you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
Yeah.
Thank you. You can both lower your hands. Mr. Kenyon, as the plaintiff in this case, I'm going to start my questions with you. Mr. Kenyon, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yeah.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
No.
Okay. Ms. Kenyon, have you been a resident of the state of Michigan for at least 180 days?
Yes.
Okay. Back to Mr. Kenyon. At that time, had you been a resident of Crawford County for at least 10 days?
No.
All right. Ms. Kenyon, had you been a resident of Crawford County for 10 days?
No.
Yes, you have.
Yeah.
Yes, you have, Joyce.
Yes, you have.
You're a
Yeah.
permanent resident there, Joyce.
Okay,
Okay.
yes.
I appreciate the help from everybody else, but when I ask a question of an individual, I have to get an answer from that person. Nobody can testify for somebody else. So just do me a favor as we go forward and only answer questions if they're directed at you, and that includes whoever else is next
Your
to you,
Honor?
Miss. Yeah. go
Your
ahead.
Honor, be lenient with Joyce. She's had several strokes, so it takes her a little bit more to answer questions.
Okay, will do. Thank you. I appreciate that information. So, all right. So, Mr. Kenyon, we're going to go back to you. I think I have a jurisdictional basis. So, Mr. Kenyon, in the judgment of divorce, there's a statement that indicates that there's been a breakdown of your relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
Yes, it was.
Does that remain true today?
Yes, it does.
All right. Are there any children under the age of 18 that were born to or adopted by you during the marriage?
There are 0.
To your knowledge, is Miss Kenyon currently pregnant?
No, she is not.
Okay. Under the judgment of divorce, you would not be receiving any alimony or spousal support you understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes, I understand that.
Okay. All right, let's see. The proposed judgment that I have indicates that you own some property together on Center Street in Frederick. Is that correct?
Yes, it is.
Okay. And this judgment is going to provide that Ms. Kenyon's going to keep that real property. Is that correct?
That is correct.
Is there a mortgage or any debt associated with that property?
There is no mortgage or any debt that I am aware of.
Okay, so you're going to quit claim any interest you have in that to Ms. Kenyon. Is that correct?
That is correct.
Okay. All right. Mr. Kenyon, are there any other issues regarding the division of assets or debts that need to be decided by the court?
There is nothing. I am totally happy with this.
All right, okay. Ms. Kenyon, were you able to hear the questions that I asked Mr. Kenyon?
Yes.
Were you able to hear all of his answers?
Yes.
Was everything that he said true to the best of your knowledge?
Yes.
Okay. Are you currently pregnant?
No.
Okay. And do you agree that you will keep that real property located in Frederick?
Yes.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both the parties. And the court will sign that judgment of divorce. So the divorce is final as of today's date. Mr. Kenyon, did you have any questions at all?
No, Your Honor, I do not.
All right, Ms. Kenyon, did you have any questions?
No. I got one question.
Okay.
He's got a boat out here. I don't know if he wants it or not.
Okay, Mr. Kenyon, were you able to hear that?
Yes, and I will be contacting Joyce within the next few weeks. I have to come back up in the area to see my cancer doctor.
Okay. All right.
Okay.
Okay. All right, thank you. That's all for today's hearing, and you're both free to disconnect at this time.
Thank
All
you,
right.
Your Honor.
Oh, yeah.
Judge, can you hear us okay?
I can, thank you. We'll go on the record in LaForge versus LaForge. This is file number 2511966. Mr. Vernon, you're appearing on behalf of
Mr. LaForge?
Mr. LaForge. And I see Miss LaForge is present.
Yes,
Miss LaForge, are you still represented by Mr. Thompson?
I am. Barry and I have done most of this ourselves. So,
Okay. Mr. Thompson has not signed in. Have you talked to him about this hearing today? Do you know if he was planning on being present?
yes, I did talk to his office this morning and they said he was planning on being present, but if he doesn't, I think that's okay.
All right. I mean, I can take a break if you want to give his office a call. Did you want to do that, or how did you want to go forward?
I think that we can go forward right now.
Okay.
Barry, feel about that?
I'm good. You know,
I mean, yeah, this isn't about whether you want to go forward. This is about whether she's comfortable going forward without her attorney present. So that's up to her.
I feel like we can go forward.
Okay, I just want to make sure you know, Ms. LaForge, that I would stop this hearing today and give you an opportunity to have your attorney present. I don't want you to feel like we have to go forward.
I understand. Thank you.
Okay, all right, and this was set for a just a status conference in this case today. And to kind of set some dates going forward. So Mr. Vernon, on behalf of your client, can you tell me, at least from your standpoint, where things are at?
So it sounds to me like the parties have a very much agreed on most, if not everything, with regards to the division of property. I was actually expecting Mr. Thompson's office to draft the proposed consent judgment that we could review. So, I mean, as far as scheduling, I guess I would ask for 60 days of discovery. And if the court wants to schedule mediation, I suspect that within the next 30 days, we're going to be asking the court for a pro-con and getting this thing done.
Okay, Ms. LaForge, do you feel like you're either reached an agreement or close to that?
Yes, definitely.
All right, then I guess, Mr. Vernon, I don't want to, I'd like to see if we can get things wrapped up without setting those kind of dates yet. So why don't I just set this for a hearing in 30 days? If we're able to enter a judgment at that time, then we can. If not, then we can set some dates going forward. It's not, that wouldn't really delay things, or you know, we can adjust dates based on what we've done here today. But that'll give the parties a chance, and you and Mr. Thompson, to get a chance to wrap this up for them without going through all those other things. Do you have any objection to that?
I support it.
Okay, Ms. LaForge, do you have any objection to that?
I don't believe I have any objections. What was the date you said? Setting something for how many days?
It would be in about a month, about 30 days.
Yes, I think we could be ready sooner than that even.
Okay, that's good. I just don't think I can get you guys on the docket quicker than that. That would probably be the quickest I can do it. And if you're ready before that, then that'll just make everything even easier when we do get to that date. So.
All right, good. Thank you.
Okay, all right. So the court will send out notice of the date and time of that hearing. Ms. LaForge, Mr. Thompson will get that notice as well. You may want to touch base with him regardless here today, just to see where the mix-up was with their office. But other than that, Ms. LaForge, do you have any questions at all?
No, I don't have any questions at all. Thank you for your time, Your Honor.
Thank you, Mr. Vernon. Anything further from your side? Okay. All right, thank you. That's all for today. All parties are free to disconnect at this time.
Thank you.